You told Judge Felice about the suspiciousness of the pictures and on the video camera, right?
Yes.
Why did you tell him that?
Because of, there was pictures of railroad yards, secure areas. There was pictures of buildings, secure entrances. There was pictures of police stations. So those were all suspicious.
Buildings, railroad yards, secure entrances, and police stations are suspicious.
Exactly.
When what?
In all the training that we received after 9/11, those were the things we were told to look out for.
Gotcha. And that creates reasonable suspicion of a crime?
Suspicious activity, yes.
Did you hear my question? You like to say the word suspicious activity. I'm focusing on words that are actually included in the law, in our Constitution. Okay? So let's talk about this term reasonable suspicion. Have you ever heard that term before?
Yes.
Do you know if that term has any relation to the Fourth Amendment?
Yes.
Does the term suspicious activity have any relation at all to the Fourth Amendment?
I don't know.
Okay, then let's talk about reasonable suspicion for a minute, okay? Did you have any reasonable suspicion that Ms. Bergquist was engaging in any sort of criminal offense?
No.
Okay. Can I ask you what was suspicious about Ms. Bergquist taking pictures outside of the courthouse? What about her was suspicious?
Well, we didn't know why she was there.
Yeah.
And we didn't know if, like then, if it had any involvement with a current case that was going on, with a domestic situation that was going on, with security procedures, any of those. We didn't know what she was doing there.
All right, so I'm not asking you what you knew and didn't know. I'm asking you what was suspicious about it.
Because we didn't know what she was doing there.
So what was suspicious about it? Because you didn't know. Who cares what you know? What was suspicious?
Well, the fact that she was trying to videotape the building, we didn't know what she was videotaping, and the fact that she refused to identify herself.
Okay, so if I understand what you're saying that unless you know why somebody's videotaping the court, it is automatically suspicious.
Yes.
Okay, so anybody recording the building, unless you know why, is acting suspiciously, right?
Yes.
And you could detain them, right?
Well, we could stop and ask them what they're doing.
And then if they refuse to provide ID, then you can detain them.
Yes.
Okay. And after this lawsuit was filed, have there been any internal discussions, other than with legal counsel, about that policy?
Just the policy they put out in June.
Exhibit 2.
Yes.
The informational bulletin. Oh, I'm sorry, no, you're talking
Policy.
about policy 172, the one that you believe allows you to detain people based
Correct.
on the subjective belief that they're acting suspiciously, right?
Correct.
Did you ever tell her that she was going to go to jail for 90 days?
I believe we informed her the judge could hold her in contempt for up to 90 days.
But you never told her, matter-of-factly, that she's going to go to jail for 90 days if she doesn't give you her ID?
I don't recall that, no.
Well, did you or did you not? Or do you not know?
I do not recall that.
Is that something that you would do and say?
No.
Okay. So is it fair to sit here today and tell us that you did not tell her that?
I say I didn't recall.
I know, but what I'm asking you is, I asked you, is that something you would say? And you said no. Isn't that what you said?
Yes.
Okay. So if that's not something you would say, then is it fair to say that you didn't say it?
I don't recall.
So it's possible that you did tell her that she would go to jail for 90 days, matter-of-factly.
I don't recall.
Did you ever tell her that she has choices? And those choices are to either show you an ID or to go to the judge who will hold her in contempt. And then he can hold her for as long as he wants. Did you ever say that to her?
I don't recall.
Is that something you would say?
It's a possibility, yes.
Is that something that's true or is that something that's false?
Could the judge hold her in contempt for
As long as he wants.
An indeterminate amount of time, as far as I know.
Really? A judge can hold somebody for as long as he wants?
Under contempt?
Yeah.
As far as I know.
After you went into your office and Larson stayed by the counter with Ms. Bergquist, right?
Yes.
And then after some time you came back out and you said to Larson that the judge is going to hold Ms. Bergquist in contempt and put her in jail for 90 days. Do you remember saying that?
No, I don't recall that.
Is that something you would do or say?
No.
Okay. Then, right after you said that, you turned to Ms. Bergquist and said, "Is that okay with you?" Do you remember that?
No.
Guess what her response was to you? Do you know?
I don't recall.
Her answer was she's going to remain silent. Do you remember that?
I don't recall.
When was the last time you watched Larson's body cam footage?
I don't recall.
Within the past month?
I don't think so.
Okay. In December of 2018?
Again, I don't recall.
Could it have been before it got cold?
I don't recall.
You then told her after she told you she was going to remain silent, you said to her, "You realize you're going to Cook County Jail for 90 days. Do you remember saying that to her?
I don't recall.
Is that something you would say to her?
I don't recall.
Then, you told her she has an option. Do you remember saying that?
No.
Do you remember what the option was?
I do not recall.
Do you have any idea what that option could have been?
I do not recall.
What option could you have given her that would have made sense? Do you know?
I do not know.
All right. You told her that all she needs to do is show you an ID so that you can do your report, and then you'd let her go on her way. Remember saying that to her?
At some point during this, yes.
Okay. So you did say that to her at some point?
At some point.
Okay. She was detained, and all she had to do was show you an ID, and you would have let her go on her way, right?
Yes.
Would you have let her keep her camera and her footage?
Yes.
But wasn't it suspicious and had to be taken in front of a judge?
But we would have had a documented record of it.
But she would have still had the pictures, right?
Yes.
You then told her that she was obstructing and she's in contempt. Do you remember saying that, matter-of-factly?
No.
No? You don't remember telling her right now you're just obstructing and you're in contempt?
I don't recall that.
Is that something you would say?
No.
Can you think of a reason why you would say that?
No.
You don't get to hold people in contempt, do you?
No.
And she wasn't obstructing anything, was she?
No.
Okay. In fact, she asked you, what am I obstructing? Do you remember that?
No.
And your answer was that you're obstructing us from doing our job. Do you remember that answer?
No.
Okay. Is there any truth to that type of answer?
Yes.
Okay. So she was obstructing you.
Yes.
Okay. Maybe 30 seconds ago I asked you and you said she was not obstructing.
Okay.
Which one is it? Was she obstructing or not?
She was preventing us from doing our report, yes.
Was she obstructing or not?
Yes.
Okay. She told you repeatedly she does not consent to searches, right?
Yes.
Okay. The only basis you had, we already talked about this, but I just want to make sure the record's clear. The only basis you had to search her purse was the detainment, right?
Yes.
And if the detainment was not lawful, then the search was not lawful, right?